Member for Caroni Central.
Thank you very much. Thank you very much, Madam Speaker. Attorney General, before I start, I just want to ask you a question based on what you just said, which is, did you mean that the Law Association responded, did not respond, or what? I didn't quite understand.
Written comments after 10 months of requesting them because they asked for numerous occasions to extend the time. They wanted an ample opportunity, so we literally waited 10 months for them, and we only brought this bill after we had received their comments and made adjustments in line with their comments.
Thank you very much for the answer, Attorney General. Madam Speaker, I listened to the Attorney General, and I am not a lawyer, as you know, so I will not deal with the fine points of the law. But I do want to respond to some of the issues, and I want to raise some issues of my own. The Attorney General said that he spent 4 years to address two particular roots of concern: the reality of crime as a business, and I want to say that I agree with the Attorney General that crime is a business, and this is a matter that should be addressed. And secondly, that he wanted to take the profits out of crime. And I want to say as well that I agree with him on that approach. I don't think that people should be engaged in any manner of criminal conduct, benefit from it, and simply proceed in the society as if it were okay. And I want to say that I fully agree with those things. But there are issues in the bill that we need to take into account, Madam Speaker. For instance, the standard of proof in this legislation is an issue that requires some attention, and I think is cause for concern. I think many of my colleagues on this side would agree that the standard of proof is quite low, and there is a burden on the citizen to prove his or her innocence that is quite great. Now, the Attorney General did refer to that in his presentation, indicating that there was no violation of constitutionality. And perhaps that is so. But I think that there is an issue here that we need to interrogate. Normally, when you go before a court of law, the level of proof that you require is beyond a reasonable doubt. That does not appear in this. And I understand the difference. Although I'm not a lawyer, I understand the difference between civil and criminal proceedings. So we do not have that issue here. There's also the concept of clear and convincing evidence. That does not appear in this bill at all. So the standard of proof is lower than these two. Then there is a concept of preponderance of evidence. That is not existent in this law either. And what we have here is really a situation in which in 58(1) of the bill talks about reasonable suspicion. So it goes even beyond probable cause and talks about reasonable suspicion, and I want to look at that for a minute. Clause 58. It says here, Part 5, Unexplained Wealth Orders. where the chairman of the Board of Inland Revenue, a customs and excise officer, or police officer attached to the branch of the police service responsible for a financial investigation, reasonable suspects that the total wealth of the respondent exceeds the value of his lawfully obtained wealth, and the property is owned by the respondent or is under his effective control, he may apply to the High Court in writing for an order, and then it proceeds with that. So, in my view, there is a low standard of proof requirement. And I want to ask the Attorney General, given his articulation on position on the bill, whether that is the best that we can do in this bill, and whether it is right to keep the bar so low in a bill as important and as significant in its implications as this. So that's my first question. This law also concentrates on the property, not the owner. The Attorney General was at pains to say that on a number of occasions. And it is my view that the innocence of the owner can be lost in such an approach. Now, I have raised here in relation to other bills the fact that the presumption of innocence before guilt is very important. And you cannot write legislation on the assumption that everybody is guilty. And I want to look at Clause 6 of this particular bill to see what it says. Clause 6 says, a property restriction order under this Act is an order in rem against property believed to be criminal property, terrorist property, or instrumentalities of crime. A civil asset forfeiture order made under this Act is an order in rem against property, which is criminal property, terrorist property, etc. So this Clause 6 is the one that relates to it. Now, what this does, in fact, Madam Speaker, is that it makes provision for a person's property to be taken away, even if a person is not guilty of a crime. Okay? So the separation of the property from the person who might own the property creates the conditions in which the AG is asking and explaining to us that it's as admissible in law to seize the property even though no crime has been proven against the individual. And I want to ask Attorney General, is it reasonable to label something as a criminal property when the property deemed criminal property is not aligned to a criminal prosecution and conviction? The third point that I want to make in asking the question has to do with the establishment of an agency, the Civil Asset Recovery and Management Agency, which the AG talked about. Now, what is the job of this agency? The job of this agency is to manage the seizure and disposal of property deemed to be criminal, terrorist, or an instrumentality under this Act. The first thing I want to ask is whether, given this law and given the public procurement law, which also has to do with the disposal of property, whether the process identified in here in the law for disposal of property is also covered by the procurement law, the aspect of disposal of property in that procurement law. And I feel it's important to ask for that because the procurement law asks for a certain orderly process of disposal of law. And one of the things that I'm going to raise here as we look at other jurisdictions is the fact that the forfeiture could be used even by an agency that is said to be insulated, as the AG raises. That agency could, in fact, be an agency that is given to and accumulation of property. So I want to look at Clause 8 here in the bill which deals with this matter. There is hereby established an agency to be known as the Civil Asset Recovery and Management Agency, hereinafter referred to as the agency, which shall be responsible for the recovery, management, and disposal of criminal property or terrorist property or an instrumentality under this act. And then it goes on to explain how it will be constituted in the rest of the pages. Now, when we look at instrumentality on page 22, we see that instrumentality of crime or instrumentalities includes, and then it defines what it includes, any property used or intended to be used in a manner wholly or in part in or in connection with the commission of a criminal offense. And B, property that is used, intended, or allocated for use in financing of terrorism and terrorist acts by terrorist organization. But by the very fact that it says includes, it means that it can be more than these two things identified here. And therefore, it gives a wide range of jurisdictional opportunity to the agency. And I wonder if this wide perspective is what the Attorney General wishes to have in this particular bill. Now, we have a problem with Clause 31.2 when you take it together with 31.1 and 33.5 and 34.1a and b and 35.2. What do all of these add up to? Let us look at 31.1. 31.1 says, where during the course of a criminal investigation, a police officer, customs officer, or the chairman of the Board of Inland Revenue has reasonable grounds to suspect that the offense involves recoverable property, he may forward an investigative report to the Director of Public Prosecutions. Then 31.1, page 39. Sorry, no, 33.1, sorry. Upon referral of a matter by the Director of Public Prosecutions under Section 31, the agency shall apply to the High Court in the prescribed form for an order to be known as a property restriction order to prohibit a person from dealing with the recoverable property until such time as an application can be made to forfeit it, the recoverable property under this act. And then at 33.5, it says an application under subsection 1 or 2 may be made ex parte without notice. So it means, Madam Speaker, that you can do this without the knowledge of the person. The confiscation of this property can be done without the knowledge of the person. And then you have 34.1, where an application is made under 33.1 and the High Court is satisfied that there are reasonable grounds that the property to which the application raises recoverable property or associated property, and it goes on. Now, how is this to be determined, Madam Speaker, if the Director of Public Prosecutions has not yet determined what action he will take? I feel that there are real problems with the contradictory intention of these particular clauses. And I would ask the AG to please look at them again to see whether I am right, or as he may well tell me, I have nothing to worry about and I am making a mistake. So 34(1), A and B. Did I deal with that? A and B, okay. And 35(2). Before varying or setting aside a property restriction order, the High Court shall give any person or who may be affected by its decision an opportunity to be heard. And I'm raising this one because it also is linked to the ex parte injunction, basically, the ex parte decision. So you have a right to be heard, but you have the matter being heard ex parte. What do all of these add up to? And are there, in fact, contradictions in this bill that we have to be concerned about that deprive the individual who is affected of rights that he may normally, as a citizen, be entitled to? Now, if you look at 45, clause 45, and the way criminal property is defined. Criminal property, it is not necessary to show that the property is derived directly or indirectly, in whole or in part, from a particular offense, or that any person has been charged in relation to the particular offense, only that it is criminal property. And it goes on to be explained, to be identified, to be elaborated on pages 50 and 51. So the person is not a convicted criminal, but the property is determined as being criminal property. And I think that there is some explanation that we need to have or understand or appreciate. And given the low bar that I mentioned in terms of proof, I think it is important to address this particular situation. We are also concerned that the issue of rights is hardly mentioned in the bill. And the first time that it's really mentioned is on, it perhaps will not be, perhaps is not the first time, but the first time it strikes you is in 48(7)(a), the rights of any person who holds the associated property or who is the accepted joint owner, etc. So that is for the person who might be affected in a situation in which someone else is having his property confiscated, but the other person has rights to the property. Now, does this bill take into account properly the human and civil rights of individuals and the rights to property ownership? Now, I know that the Attorney General took in front and he raised those issues and indicated to us that he, in fact, has properly addressed these things. But when I look at this carefully, I am not sure that it does, Madam Speaker, because it too easily moves into the court without any criminal action into the individual or against the individual, identifying the property as criminal property and then taking it into the court in order to confiscate the property. The other issue I think that we ordinary citizens, I think, would have concern about is the retroactive nature of this bill and where it leaves an innocent, unsuspecting owner. I know that there is a provision in the bill where you can go to court and explain that you are innocent in the process, that you had no original knowledge, that you had no knowledge of the situation and you simply bought the property. But I am not sure that it is reasonable to ask somebody to do that. If you have a property that has changed hands over 4 or 5 people, 6 people, and you find yourself somewhere in the middle there, or maybe the end user, I mean, how do you know? Do you go and search all of these things to find out if this property is a criminal property before you buy it? I mean, you know how many people in this country, if this were the law, could be locked up for this? Because you end up buying the property without investigating. You don't do the investigation. Your lawyers wouldn't search that. They'll search the title. They will not search the criminality of the owner. And therefore, this is an issue, I think, that one needs to be careful about. Suppose you inherit a property, Madam Speaker, and the person whom you inherited it from bought it without knowledge, or even with knowledge that it was a property that came out of criminal hands, but you do not know. Would you be penalized for that process? And I think one has to be careful how you manage the law. I mean, you cannot write the law even though you want to deal with the guilty. You also have to write the law to deal with the guilty, but to protect the innocent. Now, the acquisition of property before this law is passed is now subject to this law. Madam Speaker, the Attorney General, in fact, mentioned that in his own presentation. And I think that could be very, very problematic. If you have a situation in which a property was bought many years before the passing of this law, when you buy the property, you bought it under the existing laws at that time. Or when transactions took place before this law, they took place under the laws of this time, of that time. Can you now pass a law and on the basis of this new law begin to apply the law to a time when the law did not exist? And therefore, during the period when you acquired the property, no laws would have been broken, Madam Speaker. I think we have to be a little more thoughtful about this. I'm not saying that you didn't think about it, but no, you could reply. I hope you will reply. But if somebody, I mean, we had a famous, anyway, I don't want to use examples that, I don't want to perhaps use examples that might be disconcerting. So the main point I'm making, you pass a law today, somebody 20 or 30 or 10 years ago acquired a property, or 5 or 6 different people had change of hands of property until it got to you. All of them having bought the property before it got to you. And you having bought the property before this particular law. And all the transactions were done legally. How do you then become a criminal under this law? The property is. Well, you will explain that then. Now, given some of those issues that I've raised, Attorney General, should not this bill require a constitutional majority, 3/5? Because we are talking here about retroactivity, we are talking here about the rights of the individual, we are talking here about the rights of property. And I believe that the Attorney General is being, what can I say, too cavalier in taking the position that no constitutional rights are being violated here, that the requirements of the Trinidad and Tobago Constitution are fully taken into account. And I believe that this law requires a 3/5 majority, and I think my colleagues on this side would agree with me. Now, can you justify a simple majority, which is what the AG does? It did. on the grounds that the bill involves civil proceedings, which is what he argued, and is focused on property, not individuals. Can you cavalierly say that that is the argument that allows you to do that? I don't think so. I think that could be tested. Who is affected by property confiscation, Madam Speaker? Who is affected by the seizure of property? Is it not the individual? Is it not the person, the family, the reputation of the person? And I don't think you could just say that because it is done by civil proceedings, calling it a criminal property, that you could do that just so and come here and pass a bill by simple majority. I don't feel it can be done like that. Are you seeking to justify a simple majority Attorney General on the grounds that the property can only be seized after a judicial process? Is the AG saying that because it goes to the court and therefore it is subject to a judicial process based on this minimum standard of reasonable suspicion, that it does not require a constitutional majority here in the Parliament? I think that a citizen, Madam Speaker, should have more protection on this, because the question needs to be asked whether the process, though subject to the court, can be abused. And the question of abuse does arise. I am sure that the Attorney General sought to put in the necessary provisions to prevent abuse. He talked about the way the agency is set up. He talked about the protection under the court for the person who is the third party. And I am sure that he was very mindful of those things when he was doing and writing and organizing this piece of legislation. But you have to take this issue of reasonable suspicion and the fact that you are taking the matter to court, and you can't justify that and say that because it is going to court that it is simply a simple majority piece of legislation. How come the Proceeds of Crime Act required a 3/5 majority, Madam Speaker? And this bill, which seeks to seize property, does not. I have a problem with that. And you can't tell me one is the property and one is the person, and that is the difference. In many states in the United States, Madam Speaker, I know that he used Commonwealth jurisdiction, and in this Bill Essentials, they use the Commonwealth countries of New Zealand and Canada and Australia, etc. I know that. And he used some of the Caribbean islands as well. In many states in the US, they have increased the standards of proof to require proven criminal guilt before assets forfeiture can take place. And this is a fact of life, and I will demonstrate it. You have a situation here with the chairman of the BIR. I have no doubt that every chairman of the BIR will be above board and above suspicion. But we have had many attempts here with different legislation which the opposition had to challenge successfully for information from the BIR being accessible outside of the jurisdiction of the BIR. That is a matter that has come up in the legislation here. We have protested vehemently on these. I could think of the Tax Information Treaty Amendment Bill. I could think of the FATCA bill. All right, I am sure it's going to come up again in others. You have a situation of customs and excise officer. If you ask any of the members opposite, including the Minister of Finance, he would tell you, if he doesn't want to speak in the Parliament, he may tell you quietly that one of the reasons that they want to create another institution, you remember the House, aren't you? So, I'm not making any controversy, man. I'm just making a point. One of the reasons they want to establish a new institution to deal with customs and other institutions is because they feel that there exists within the Customs and Excise Division a certain amount of corrupt activity. They will tell you that. And these are the people now.
Honourable Member for Caroni Central, your original 30 minutes suspend. You're entitled to 15 more minutes to wind up. Are you
Yes.
availing yourself of
Yes.
it? And honourable members, can we agree to take the suspension on the completion? It'll be
Thank
just
you,
4
ma'am.
minutes after.
Thank
Please
you, ma'am.
proceed.
So here you have an institution which itself is under suspicion, now in charge of determining that you are under suspicion and bringing you to court. And then you have police officer. Yes, they are in charge in investigation, but I have made this point in relation to another bill. If you're going to give this kind of authority to somebody in the police service, give the authority to the commissioner of police, because he has constitutional authority. And let him pass on to whichever officers now accountable to him who can do these things, whether they are investigation officer or whatever it is. When you look at the civil asset trustee, yes, some attempt is made to have jurisdiction of the judiciary, and then you have the leader of the opposition and the prime minister. But I don't know if that is enough insulation. And then the property manager has the powers of a receiver. And they all have, under this bill, Madam Speaker, immunity basically from any kind of challenge or prosecution, you know. That agency has complete authority and control. But then you have the other issue where the Minister of Finance is involved in a key role, 34, and although the institution properly accounts to Parliament, the Minister of Finance does have jurisdiction over the authority and does provide actual direct financing to the institution. So the political insulation that you talk about, I'm not talking about this Minister of Finance, but any minister who is involved. If you want political insulation, you have to make up your mind that you cannot have a situation in which the institution can be, in fact, subject to any kind of political influence. So I was talking about the United States jurisdictions, Madam Speaker, and the fact that they have changed a number of things. In many states, I'm reading here from a document, I will let the Hansard know what it is, legis brief. And it says, in many states, the standard of proof is a preponderance of evidence, okay, which is higher than we have here. And in many others, proof not only of a preponderance of evidence, a clear and convincing evidence, making it more difficult to seize property. Then it says that states are working to clarify and protect the rights of property owners by improving the process. All right, opponents of civil asset forfeiture laws cite a heightened risk for abuse because in many states, law enforcement have the incentive to seize property as they receive some or all of the proceeds from the sale. This institution here, the agency, is not insulated from this, you know, Madam Speaker. It can become a law unto itself. It could become a property owner. And under political influence, it can become a very, very problematic institution because all kinds of things have happened in this country. I think you know that from the transfer of ownership of state lands to individual people, to the transfer of other assets to individual people in the process of political influence. And I'm not talking about any individual or anything like that. And then in the HR 5212, which is a piece of law, I wanted to get one piece here, though, which had to do with the fact that in certain territories, they have made it absolutely necessary that the proof that is required is criminal conviction before you could seize the asset. 9 states in the United States. I cannot find the paragraph here now, although it's only 2 pages, but I can tell you in 9 states in the United States, the burden of proof, the trigger is criminal conviction of the individual before you can go. And then in this Civil Asset Forfeiture Act, Reform Act 2014, you can see here what they are doing. In paragraph 1, by striking by a preponderance of evidence and inserting by clear and convincing evidence. So they are increasing the bar. Over here, where a prima facie case is made for such a defense, the government has the burden of proving that the claimant knew or reasonably should have known that the property was involved in illegal conduct giving rise to the forfeiture. So you have to prove foreknowledge before you can take the property. And in making this determination, the court shall consider such factors as the seriousness of offense and so on. And all right. The piece that I wanted to get, thanks to my colleague here, the member for Chaguanas East. In the last 2 years, Arizona, Iowa, and Virginia enacted laws changing the government's burden of proof from a preponderance to clear and convincing, and making it more difficult to seize property. That wasn't the one I was looking for. It's the one where the 9 states have, in fact, taken the burden of proof as being a criminal conviction in the thing. Now, as I said, the Proceeds of Crime Act require, now, I will go on, Madam Speaker, because I know I have limited time now. Is the bar for the standard of proof too low? And should it not be raised? I want to ask the Attorney General that. Is it unreasonable to argue that initiation of proceedings to restrict access to property or to confiscate property should be after conviction for a crime and not on suspicion? Now, secondly, are the various definitions, especially under Clause 4, which is the interpretation section, are they too wide? Are the powers not too arbitrary? And can they not be subject to abuse? And I've illustrated how they can be abused. And does this law not allow violation of due process? Is this law, as it is, not subject to potential political abuse? When one takes into account retroactivity-related bills like the evidence bill and retroactivity and related bills like the evidence bill and others, where as an opposition we've had to fight for secrecy for the BIR, to restrict the potential for abuse by police operatives, and for protection against violation of human rights and privacy rights against citizens, as well as property rights. Can't you see here, Attorney General, the potential for the abuse, notwithstanding the fact that we agree with you that you intended, in fact, to insulate this particular institution? Should we not be cautious about this? And does this law, therefore, not violate essential constitutional protection? Now, the AG talks about proportionality and justice and so on. And I have a case here on my phone in the United States in which a convicted petty criminal involved in drugs was disproportionately, in the view of the judge, had his property taken away from him, in addition to a jail sentence and a fine that he received. And when the matter was appealed in court, the judge ruled that even though he was a convicted criminal, that there had to be some proportionality between the nature of the crime and the command you were taking of the person's assets. And just to save time, I don't want to go and read it now. But again, that is an issue, but we are dealing here not with criminals, but people who are not, in fact, convicted at all. Now, I understand that this is meant to be a good piece of law that protects the innocent from the guilty. I know that it has to do with drugs and guns and violence and money laundering, crime, terrorism, corruption, hidden and protected assets, etc. Now, I know that this is also the situation that led to this kind of legislation the world over. And you had a situation that in which you had to find other ways of getting criminals that you could not ordinarily get given the existing law. I understand all that. I recognize the Attorney General's position on several occasions here when he came and said, you know, they didn't get Al Capone on criminal charges for the murder of people or the conduct of criminal activity. They got him on tax evasion. I understand that. I also understand that in the case of Dole Chedi in Trinidad, he was convicted for murder and not for any of the crimes that he committed allegedly related to the notion of drugs and drug trafficking and those kinds of things. I know that this is an issue, but I think we have to be, I also know that there's a compliance issue with the Europeans and the European requirement to allow us to be part of a set of civilized nations in terms of the way you manage your financial system and the way you manage your financial and economic system. I know all of that. And I know we have to get off the blacklist. All right? The AG never mentioned this, but this is one of the issues. We have to get off the blacklist. I know that. I understand all of that. But that does not mean we have to violate the rights of individuals. That does not mean we have to take away people's property just so. That does not mean that you have to have a bill with such overreaching powers and overpowering clauses that you basically put the ordinary person at a disadvantage. Now, the AG said, if you are an innocent person, you don't have to worry about this bill because this bill is only for criminals. But the problem with bills like this, and the problem of the potential for political interference, and the problem of the potential of manipulation by officials who have the power, and the potential for agencies such as we are establishing here for becoming self-serving institutions in their own right. Reality, life, the experience, the cases that we know tell us that these things do happen, Madam Speaker. And therefore, you have to always write legislation for the innocent, to protect the innocent. You cannot allow a person who is innocent to find himself in a situation, him or her, all right, before the court, trying to grapple with the fact to prove their innocence and to explain how they got their property and so on. I mean, there has to be some circumscribed area, and there has to be some element of restraint even while you bring the power of the law against the guilty. And then you can seize their property, you can take all their assets, etc., always with the principle of proportionality at work. You must do that because you can't take all their assets if the crime does not require you to take all of their assets. So there has to be an element of fairness and justice. So, Madam Speaker, this is my contribution here today. I hope the AG appreciates my point of view. We appreciate where you want to bring this legislation, why you want to bring it. But given all the other legislation we have related to this, and given the fact that the issue of human rights and property rights are very important consideration, I would say make this a law for the criminals and protect the innocent. Don't allow the innocent to go down with the with the guilty. Thank you very, very much.